So let's go ahead and get started. Welcome everybody to tonight's Superior Court Judicial Candidates debate. My name is Elizabeth Larson and I'm with Lake County News and I'm tonight's moderator. Tonight we're joined by our two candidates in the fall runoff, Don Anderson and Shonda Harry. Thank you both for being here. It's a busy campaign season, so we appreciate you being here with us tonight. We will be starting out with a format that you've probably seen before. We're going to have openings, we'll have closings, and we're going to have two separate sets of rounds of questions. We've gotten a lot of questions for this event tonight. People are very interested in this race for obvious reasons. So we have a set of questions that are very general for both, and then we have a set of questions that people submitted for a specific candidate. So we want to give chances for people to get their questions answered both ways, both generally and specifically. So we're going to start off after our openings with the general round, and then we'll move into the specific round. And then we'll end the evening with closing statements and wrap up. During the debate, if you get a good idea and you want to submit a question, we have 3x5 cards, and Andy Lucas of the Lake County Economic Development Corp., which is Lake County News' co-sponsor for tonight's event. He will be making his way through the audience, so don't hesitate to wave your hand if you'd like to submit a question. We will try to get all questions answered if we possibly can, but like I said, we do have a lot already, so we'll try to shoehorn them in where we can. So let's get started. We want to do our opening statements. We're going to go in alphabetical order, and we will start with Don. You get just 1 minute.
Thank you very much for being here tonight, the audience and the listening audience. I want to thank Elizabeth and John for putting this on, and Shannon for being here also. This is probably about the 10th or 15th debate I've either participated in or attended that Elizabeth has put on. So I know tonight was going to be a very interesting and robust debate, and we're looking forward to it.
Thanks. Shonda.
Good evening, and thank you for being here. My name is Shonda Harry, and I'm running for Superior Court Judge. And I too have been through a lot of debates, and I'm very excited to hear your questions and answer any questions you have and have a lively debate. And I also think that these forums are wonderful, and I appreciate the fact that not only are they done in this building as well, but also can be viewed on the internet, on the website. So with that would be my introduction.
Thank you. Okay, let's get right into the questions. Again, this is the first round of general questions that are posed to both of you. You will each get 2 minutes to answer a question. And this won't be so much a debate format, it's just a simple question and answer. We'll get into more of a debate format with the other round of questions. So we did a coin toss to determine the order of who would answer these questions, and Dawn won and deferred, so Shonda will get to go first. So the first question, and again you get 2 minutes to answer. Please state your views on the new state law doing away with bail and how you will implement this law in your criminal cases. How do you think that change in law will impact local judges?
So I think I had said previously in other debates that I did believe that there was some necessity for bail reform. I was somewhat surprised when bail was sort of done away with entirely, but what I think this is going to do in terms of the local judges is, for those of you who aren't aware, the presumption in the bail statute has been changed from what it was originally, from the original bail legislation was changed from a presumption of release to a presumption of pretrial detainment. So what that means is that the decision on whether to detain someone, pretrial specifically, is going to be strictly in the hands of judges. And I think that will impact the judges here immensely. I mean, the judges everywhere at the Superior Court level immensely, because there will no longer be bail, and so the decision is going to be in the hands of the judges. There's been some concern that everyone will err on the side of caution and keep everyone in jail, but I don't think that's going to be the case. The Judicial Council will be responsible for setting standards as to what formulas and matrices are going to be used to determine a risk assessment for pretrial detention. And I think that we're going to have to wait to see what the Judicial Council comes up with, because now it's up to them to implement the law, as well as up to judges to make those decisions. I think it's going to increase the workload, and I think it's going to require that every case be reviewed very stringently, because bail to some degree was an easy decision to make. There was a standard bail schedule. So I think that we don't exactly know how the law is going to sort of shake out at this point, but at the very least it's going to impact the workload and the responsibility of judges.
Thank you. Dawn?
Okay. Well, prior to the implementation of this law, there was a need for bail reform, and I think everybody in the judicial system recognized the need for it. Unfortunately, like many other issues, the legislature has gone maybe a little bit too far to one way to try to correct a problem. What this bail reform is going to do is going to take the possibility and the likelihood that a lot of criminals are going to be put on the streets that should not be on the streets. It's going to be up to a judge to do one of two things: either release them or keep them in jail. And there's no in-between, unfortunately, like there was in the bail system. So a judge is going to have to look at two main things. The first and least important will be the possibility or probability of the defendant showing back up for court. And I think what we're going to see is a lot of people not showing up for court, and the cycle is going to continue. You can get a lot of warrants for their arrest, and they'll get arrested and come back, and it's going to slow the process down. But the most important thing is a judge has to decide whether or not the defendant poses a risk of safety to the public. And that's a difficult decision for any judge to make. You're trying to look into the future and decide, should this person be out on the streets, or is he going to reoffend? So that's something we'll have to wait and see. And it's going to take a lot of, I'd say, judicial temperament, knowledge, and experience to make those decisions.
Thank you. Question number 2, we start with Dawn. What is your view of assisting pro per or self-represented litigants who cannot afford an attorney, especially when the other party has retained an attorney?
You have to treat pro per litigants just like you would treat anyone else. A judge cannot take sides. They cannot be favorable. Just because someone has an attorney, you can't treat that side any different than you can treat somebody else who's in pro per. However, that being said, when you have a pro per litigant, whether it's going against an attorney or two pro per people going at it, they have to know the process and the procedures. And a judge can only go so far as to explain what those procedures are. But I think a judge is incumbent on a judge to help, maybe help is not the correct word, but inform the impropers and sometimes even the attorneys what the law and the procedure is, and see to it that they adhere to it.
Thank you. Sean?
So over 50% of the people who come through the civil courts here are unrepresented. It's probably even higher than that, but that was the statistic I was given. And so what you end up with is a very large number of people who come in front of the courts either, I mean, mostly neither party are represented, but you do have a large number of pro per. And Dawn is right. What you cannot try their case for them. You as the judge cannot favor one side or the other. Pro per means they're representing themselves. What I do think is important is to make sure that everyone in the courtroom understands what's expected of them, that the courts don't play, I want to say, hide the ball, so to speak, and that everyone is aware of what is going on in the court. I think that's part of what I stress, which is this procedural justice that I'm interested in. On the other hand, I do think that there's some mild light at the end of the tunnel, because in the recent budget that came out of the state, there's going to be additional funding for self-help services for litigants, more availability of information for them, and hopefully the courts here can access those issues. So I think that it's the judge's responsibility to make sure everybody understands what's going on, understands their role in the court, but obviously the judge cannot try the case for the pro per litigant, nor can they favor the person who has the attorney. So I think it's incumbent upon the judge to make sure that everything is clear and understandable to the people who are in the courtroom.
Thank you. Just as a quick follow-up for both of you, in your experience here in the courthouse, are you seeing more of those types of litigants, more self-represented folks making their ways into the courts? Sean?
I believe there are. I mean, it isn't an issue as much in criminal matters, because I'd say 95 or plus of people who appear in criminal matters qualify for a public defender. But in the 10 years that I've been practicing in and around this court, I have seen less people represented by attorneys and less attorneys representing their clients in the court. So I would say it is becoming an issue where more people do represent themselves.
Dawn?
Yeah, just a 30-second response.
Yeah.
Okay. Yeah, I agree that the number of pro per litigants have increased, but not that drastically. When I started doing family law almost 30 years ago, we had our share of them. In response to Shanda's comments, self-help programs do help you fill out paperwork, but they don't teach you how to be a lawyer, and they don't teach you what questions to ask and what questions not to ask. It's going to be incumbent on a judge, any judge, when you got especially in pro pers, to ask factual questions of the litigants and the witnesses so that they can make an informed decision. If an improper doesn't ask the right questions, a judge can't make decisions just willy-nilly. So they're going to be incumbent on asking questions themselves.
Thank you. Okay. Next question, we'll start with Shonda. What innovation would you seek to bring to the Lake County Superior Court as its newest judge?
I think that I would like to work on issues of technology. There, again, in the budget, there are abilities to access funds for example, other counties have availability for fax filing, this type of thing. We don't. And so our cases aren't online to the same degree as other counties. And I think that to the extent that money is available for technological infrastructure, that would be helpful. I do also believe that a number of counties have, I wouldn't know if it's modernized, but have improved court services by using specialized courts. And this is where I would like to discuss things like a mental health court, expanding drug court services, and expanding veterans court services. These, again, are things that there are monies available for in grant forms to increase these type of courts. And I think that it would go a long way to helping the backlog of the cases to have these other areas that these cases could be heard.
Thank you. Thank you. Dawn.
Okay. You know, we have some outstanding judges in this county, and they do a very good job, not only deciding cases, making decisions, but procedurally they're doing everything they can with the money they have. Obviously, if we get more money, we can do more things, but right now, even with the increase in the funding by the state, there's really not enough money to do a perfect job here. I was part of setting up the Veterans Court, and it's been a great asset to the county. And I want to keep doing things such as this. Mental Health Court, which I'm sure we'll be talking shortly, is great in concept, but with the new legislation, I don't know how it's going to work. We're going to have to see what the new legislation is going to pan out to be. The stuff I would like to do more is centralize the services that either criminal defendants or sometimes even civil defendants have to go through. Say like AODS or drug services or community service programs. Unfortunately, if somebody is sent to AODS, community service, they have to leave the courthouse, go to a different location, and sign up for it. You know, it takes a long process to do that. If we have the resources available, I'd like to implement a program where we have one person at the courthouse who's able to sign people up there at the courthouse, make sure it's done right at that time, And it will relieve a lot of litigants having to come back time and time again and not signing up and just slowing down the process.
Thank you. Okay, next question, we start with Dawn. In family law, what is your view of false allegations of abuse against the other parent? In other words, how would you as a judge handle such allegations? And when would you order an investigation?
Well, this question is kind of near and dear to me. It's something I've been working on for the past several years. If a judge is not presented with the truth, false allegations are going to be made and decisions are going to be made based upon these false allegations. As a judge, I would almost demand truth. And when you don't get truth, then it becomes perjury. I implemented the first perjury unit in the United States a few years ago. And that perjury unit has been very successful. We have prosecuted approximately 10 individuals. We've gotten high publicity, and each individual that we prosecuted has been convicted or is still in the process of going to court. As I'm told by judges, attorneys, and litigants, it's made a difference. There is much less blatant lying going on in court now as there was before this unit was created. I would continue such if as a judge, someone blatantly lies in court and it's approvable, I would make a referral to the district attorney's office for their investigation into it and prosecute that way. And besides the litigants, oftentimes you see the attorneys, I don't want to use the word perjury or lying, but stretching the truth. And sometimes you can't charge them with perjury because they're not under oath, but it doesn't mean you can't take them to the bar and report them to the bar, so they have to answer to the state bar why they are in essence lying to the court.
Thank you. Shonda.
So I think the thing about family law that needs to be encouraged is for cases not to get to the point of coming in front of a judge. I think that there are a lot to be said for focusing on mediation, and I know we have mediation here for family law. Someone did make the joke that if you want to read a good piece of fiction, read any transcript from a family law case. So I think that judges have to be aware that, and to be honest, I don't think it's really a joke, but judges have to be aware that emotions are high in these type of cases, and to keep track of that. In terms of when to refer cases, you know, depending on the type of case, there are court investigators that will go out and investigate issues for the court themselves. And this happens in family law, it happens in family law cases that are attached to CWS cases. And so I think that the important thing when it comes to lying or falsehoods in a case is not that they happen so much, but that you make sure that the wrong decision isn't made based on those. So I think that referring them to investigators that work for the court would be the first line of attack. But I think that a judge just has to be very aware of and very aware of what's going on in their courtroom and make the decisions based on the facts that are presented to them.
Thank you. Next question, start with Shanda. How would you prepare yourself to handle cases involving unfamiliar areas of the law?
So, the current job I have at the county counsel's office, we do vastly different types of law in any type of day. We have when I was at the DA's office, I tended to prosecute the same cases over and over again, but at the county counsel's office, one day we'll be dealing with, an agriculture issue, in the afternoon it'll be something to do with a criminal administrative hearing. So I'm used to jumping in and having to find out what's going on. First of all, judges have judicial bench books, and it gives you a guide on what you need to what you need to understand about a particular case. Not a particular case, but a particular type of law. Also, I just believe in extensive research. You go out, you read the treatises on the particular issue, you find out as much as you can, and that's sort of always the way I've done everything, is getting as much information. And I honestly don't like to always depend on any breakdown or treatise entirely. I always check the sites. So that's basically how I would do it.
Thank you. Dawn.
Okay. Yeah, despite the experience a person has, either as a lawyer or as a judge, there are so many issues that come up you don't know the answers to.
Mm-hmm.
And in essence, what a judge has to do, he has to take the time. And like now, I've been doing criminal law for 28 years or so, plus my time as a deputy sheriff. And there's constantly areas come up I don't know the answer to. Talking to other people in the office, they don't know the answer to. So we just have to sit down, take the time to do the research, find specifically the cases that deal right on point with the issues. And sometimes that doesn't even work. Sometimes there are no cases. So you make your best decision you can, and if it's wrong, then it goes to the appellate court and they make a decision. Or they create new law.
Thank you. Next question, we start with Dawn. What effect will the legalization of marijuana have on the Lake County judiciary?
It has already made a significant effect on the judiciary. And basically what it's done is lighten the load. I remember back when I started in law enforcement back in 1975, we were sending people to prison for little film canisters of marijuana, just possessing it. And now it's gone to a point where you can have pounds of marijuana for sale, and it's minimal imprisonment. The maximum punishment is 6 months in county jail at halftime. So now that marijuana is almost legal, and even the cultivation of marijuana is almost legal, it's lightened the load for the courts. And it's no longer, unfortunately, it's no longer thought to be a priority. Whether you believe or whether you agree with it or not, that's just the hard facts of it.
Thank you. Shanna.
So I think one of the best things that's happened with the recent legalization, quasi-legalization, is there's clarity. I've been handling issues of marijuana, whether it's in a civil matter or a criminal matter, for 10 years. And what you were always saying was, okay, well, let's wait till the next decision comes out. Or okay, the City of Riverside case came out, let's try the next case. Let's see what happens. Now we have a legal framework. Whether you agree with it or not is not as important as, from a judge's perspective, as knowing what the law is. From a perspective of how things are going to be handled in Lake County, this has now moved, marijuana has moved now mostly into the civil arena. Do you have a permit? Are you growing it in the right place? Zoning issues. And these particular issues do take some pressure off the criminal courts, because it's now an issue of where, not if. And so I think Don's right, it's probably going to lessen the criminal caseload. I do believe if people are not in compliance, some of these cases are going to eventually work their way up to the court in a civil capacity.
Thank you. Next question, we start with Shanda. Please describe your first-hand experience dealing with people who are different from you socially, religiously, economically, or politically.
So for me, I have been with people who differ from me religiously, racially, socially, economically for my entire life. As I've mentioned in a couple of events, I grew up in a household with religious differences. And one of the things that I learned, I never understood when people said they couldn't talk about religion or politics. I always thought that, of course, you should talk about religion and politics with family. You should just learn how to discuss them with an open mind and understanding of other people's views. And also, I grew up in Los Angeles, and I went to what are called magnet schools. They're for voluntary integration, and so by definition, you can only have a certain percentage of non-minorities, which I would qualify for, so, or as. And so it's an interesting question because it's just always been a part of my life. I'm used to dealing with people who have different views than I do. I'm used to dealing with people who have different lives than I do. And so it's something I'm very comfortable doing. And I think that it's a skill that I feel that I've learned over the years of how I was raised.
Thank you. Dawn?
Yeah. You know, either fortunately or unfortunately, almost all of my life, at least my adult life, has been involved in dealing with people on a constant basis of different orientations, ideas, philosophies. For 15 years as deputy sheriff, I've dealt with every type of individual, both on the good side and both on the bad side. I've arrested the worst of people, and I've arrested friends. You have to deal with it. Spent 20 years as a private attorney, and usually the litigants that litigants or your clients are usually good people. You're trying to help them out, and most of the time the other side are good people. Your differences come in with dealing with other attorneys. Like there's an old saying is, you know, the reason copper wire was invented is two attorneys fighting over a penny. And unfortunate, but it's sometimes true. And in my last 8 years at the district attorney's office, I deal with a lot of victims on a daily basis. They have very serious problems near and dear to their lives. You have to show compassion, you have to show firmness. There's a lot of things that, and I can't express enough the wide variety of people I deal with on a daily basis. And I've actually come to enjoy it, learning different cultures, learning different philosophies, and trying to deal with it. It's been pretty effective so far.
Thank you. Next question, we'll start with Dawn. What are your thoughts on the recent legislation regarding the changes to the felony murder law? The new felony murder law, SB 1437, goes into effect on January 1st and deals with accomplice liability. Previously, accomplices could be held to the same standard as a person who actually committed a killing and could be convicted of first-degree murder if they were participating in a felony during which a person died. Now they can only be convicted of murder if they are proven to have had the intent to kill or were a major participant in the underlying felony act.
To be quite blunt, it's a disaster on the criminal justice system. We're talking usually the felony murder rule, major crimes. I'm going to give you an example. Now, say for instance, you get two guys going into a liquor store and they're to commit a robbery. They got, say they have one gun between the two. They shoot and kill the clerk. But there's no way through evidence or witnesses or anything else to determine which one of the two people shot that gun. So you cannot charge them with murder. The best you can do is charge them with a robbery. That's under the current law now. Well, no, I'm sorry, that's the new law that will come into effect. Now, as it stands, you could charge them both with murder. Because if you commit a major felony, there's enumerated felonies that apply, and somebody gets killed, then both of them can be guilty of murder. Now you're going to see a lot of people not charged, not convicted of major homicides because of this law. And like other laws that have come into effect the last few years, it's just going to be a disaster to see that justice is completely gone.
Thank you. Shanda.
So, Mr. Ennis' analysis of the new bill is actually not correct. The case that he just described could still be tried as under the new quote-unquote felony murder rule. The definition of it is the person has to be a major participant in the underlying felony and acted with reckless indifference to human life. So that scenario would still come under the quote-unquote new felony murder rule. What they did was, it was kind of interesting because what they did is a bipartisan group of senators, or I'm sorry, of assembly people took the rule and clarified it and required this acted with reckless indifference to human life. Shooting people in a hold-up robbery would still qualify under that felony murder rule. So I don't think it's quite the Armageddon that people are making it out to be in terms of criminal justice, because it's in a sense been just further defined going forward as requiring this act of reckless indifference, and shooting a guy in a robbery would qualify for that. So I think that it's going to cause some headaches, so to speak, because people are going to go back and ask for resentencing, so there's going to be a congestion in the court. But I do think that the underlying concept with it, which is sort of this historical transferred intent for commission of a felony, can still be prosecuted under the new law.
Thank you. Quick follow-up for both of you, just real quick. Dawn, are you aware if this new law will have any impact on the Provocative Act murder?
I'm sorry, on what?
On the Provocative Act murder law that has been used, is this a similar or same thing?
That yet remains to be seen what effect it will have. But I will say, Ms. Harry and I have a disagreement on the felony murder rule. Is my recitation of the facts that I said, it's accurate.
Shanda, what's your knowledge about Provocative Act and possible impacts on that?
You know, to be honest, this rule is so new, having just been signed a few days ago, that I think that I can't make any informed discussion on that. But I do believe that, I mean, this will have effects, no doubt, but I don't think it's going to impact as many aspects of the law as perhaps people might be concerned that it does.
Thank you. Next question, we start with Shanda. How long do you plan to serve as a judge on the Lake County Superior Court if you're elected?
So I was on a radio show recently, and the person interviewing me just blatantly asked how old I was. And I sort of get used to people asking me that, or asking me, are you really old enough to be a judge? And the answer is obviously yes. I've been an attorney for almost 18 years, but I plan to serve as long as the people would keep electing me. I have a good 20 to 25 years left in the time that I would be the normal time that people continue on in their careers. And what I would like to do is be on the judiciary, and I've talked a lot about things that are long-term projects, you know, the mental health court, the modernization, those type of things, and I would like to do the job as long as people would have me.
Thank you. It must at least be nice to be asked if you're old enough to be a judge still.
Yes, at first I basically wanted to say thank you, and then I realized that may be not the best response.
Does anybody else that of you, Dawn? Are you old enough to be a judge?
I think so. Very advanced kids tell me I am.
All right, so your question, how long would you plan on serving as a judge if you're elected?
Let me start. I listened to the same radio show that Shanda just mentioned, and she mentioned on the radio show that I made a statement I'd only be served part of my term for 2.5 years. I don't know where that information came from. I've never said it. I never even thought it, let alone say it. I have to plan my term one term at a time, which is 6 years. I definitely, with no doubt, is going to finish out my first term. After that, it's going to depend upon my health and your mind. It's just not only myself, same way with Shanda, with any other judge. If their health and their mind does not hold up, then they're done. That's all they have. So I cannot envision myself retiring at any stage. I am not one to sit at home and watch General Hospital. I've got to keep coming and going and doing all the time. So as long as my mind and my health is good, then I'll plan on sitting on the bench that long.
I can play the tape.
But once I become a deficit to the system, then it's time to put me out to pasture.
Thank you. Okay. Next question. Question 10, we start with Dawn. This week, the Lake County Grand Jury came in for some harsh criticism from the Board of Supervisors over its latest report. Some of the issues with that report, according to the board, were what they termed its unfair assessment of county staff and the handling of disaster response and recovery, as well as editorializing and disrespectful headlines. Board members agreed that the grand jury is wasting the time of county staff and that the reports have been, quote, nonsense. How would you as a judge address concerns over the grand jury? And we start with Dawn.
Well, I think first, which is done, the grand jury has to be instructed on what their duties and their responsibilities are. And grand jurors do go to class to learn how to become a grand juror. What happens after that? Well, they do the year-long reports and deliberations and discussions and investigations. Is up to the individual grand juries. There's 19 grand jurors, so you got 19 people going different ways. I read the grand jury report. It is by far not nonsense. You have 19 people volunteering their time. These are good community people, doing the best job they can. I've been appeared before the civil grand jury on many occasions, and they are trying hard. And to sit there and be picked apart by the Board of Supervisors and ridiculed for their job, in my opinion, is a disgrace on the county. And I totally side with the grand jury on this. Maybe they didn't hit all the issues, maybe they didn't do a good job here or there, but that's on any governing body or any body that investigates anything. They don't get everything. But we should be complimenting these grand jurors for the effort and the time they put into it, not ridiculing them on what they believe are the problems that they see.
Thank you. Shanda.
So I would have to agree that the grand jury does a service to the community, and especially to the county. And you know, obviously they point out concerns that they find. The grand jurors go through training, and it's essentially a volunteer position. So I have great respect for what the grand jurors do. I think it's important to note that grand juries change every year. They're not static bodies. The people who are on it change. And so the things that they focus on are going to change every year. I have to say that we should look at what the grand jurors have to say with a lot of detail. And sometimes they're wrong, sometimes they merely have to have more information, and those issues have to be explained. I've been in situations in my current job where, you know, grand jury responses have to be written, and sometimes you have to clearly explain why the situation that they saw as a problem is inevitable or has to be done this way for various reasons. And it's important not to criticize them, but to simply clarify the situation. So I am honestly unsure, having not seen the Board of Supervisors hearing, to know what the exact concerns were, but I too read the grand jury report and I did not have the same issues with it.
So both of you have had experience then responding in writing to grand jury reports, then I would assume. You as county counsel and you as district attorney. Yeah, we don't, in a sense, draft them in our office, but we advise departments, because sometimes grand juries point out an issue where there's an underlying legal issue that has to be clarified, that, you know, we may not want to do something this way, but we have to because of X, Y, and Z law. So, and Dawn, you?
Yes, I've been in the DA's office for 10 years, and I'd say probably 7 of those, we've had an issue come up with the grand jury where my office has been investigated. And every time it's been fine. There's been a couple of suggestions the grand jury has made, Some I agree with, some I disagree with. But I do recognize, and I always have recognized, their position on every issue they bring up, even if I agree with it or not. And I appreciate their input.
Thank you. Next question, we'll start with Shanda. As a judge, how would you balance the rights of victims with the rights of criminal defendants?
That is the main question. That is what judges have to do. And I believe that the most important thing a judge can do when making their decisions, whether it's victims or defendants or plaintiffs or plaintiffs or defendants, is listen. And that is listen to what's being told to you in the courtroom, understand what needs to be done. I mean, one of the things that I've always been interested in is what the victims actually need. Because sometimes a victim doesn't necessarily need that person to be incarcerated. What they need is restitution for what's happened to their property or something like that. So I think that balance requires finding some sort of middle ground between punishment and making sure that victims are made whole in a situation.
Thank you. Dawn.
Okay. A judge has to be neutral. You can't take the side of the victim, you can't take the side of the defendant. If a judge follows the law and strictly enforces the law, the situation will take care of itself. A judge is required, let's say for instance, to order restitution when available, which is, restitution is always in favor of the victim and against the defendant. But he's following the law, and the law as it is written is generally right on point. It's using common sense. As long as the judge does that, he's going to be fine.
Thank you. Next question, we'll start with Dawn. We talked about some other legislative changes that will have impacts on the Superior Court, but I'm curious for each of you to say what bill signed this legislative season do you think will have the biggest impact on the Superior Court's operations?
I'm sorry, the question is Superior Court operations?
Yeah, well, the Superior Court as a whole. What bills has the governor signed into law that you think will have the biggest impact on the bench?
Well, it started about 5 or 6 years ago when they passed AB 109, which is the realignment bill, which put a lot of criminal defendants back on the street. Then they went into Prop 47 and Prop 57, which made some felony crimes misdemeanor crimes. Now they've implemented the felony murder rule revisions. But I think probably the biggest and the most devastating bill was passed like almost the middle of the night without much publicity, which is AB 1810 and Senate Bill 215, which is recently modified it, which is the Mental Health Diversion Act. And what that says is if you have a mental illness, and that mental illness, which are approximately 75 of them, including cannabis addiction, and that substantially causes you to commit a crime. Now, the original bill said any crime, including murder. It's been lightened up a little bit now where murder doesn't apply, and some child molest cases. But anyway, if that mental illness substantially contributed to a crime, you're eligible for a mental health diversion program, which means if you go through this program, which nobody knows at this point what the program looks like, for 2 years, and you complete the program, it's wiped off your record. Just yesterday, today, I accepted a plea from someone for human trafficking because she has a mental illness. And we worked out a good deal, a fair deal. Had she not taken that plea, she'd be eligible for diversion. And after 2 years of going through a program, she would not only be set free, I mean, she would be free the whole time, but it would be wiped off her record.
Thank you. Shanda?
I would have to say that the new legislation having to do with the elimination of bail is going to be the most significant thing that's been recently signed. It's, California is taking a step that is, they're pretty much the first in the nation to do this. And it's up to the judiciary now to come up with how this is actually going to work. And I think that, or not work as the case may be. So I think that nothing is going to be more significant in terms of, well, the governor has recently signed as that particular issue, because it changes the whole way incarceration is understood in California. And, you know, as Don just said, there started to be a shift in things with AB 109 and moving people from state jails to local jails, and that is going to be impacted. That in combination with the recent bail legislation is going to have a huge impact on the local justice, well, the local courts, but the local justice system in general.
Thank you. Do we have any more general questions for the audience before we go into the specific questions for the two candidates? I don't see anybody waving their hands. Okay, so we're going to now move into the second round of questions. Those were the general questions for both of you. These are going to be questions that are more specific to each of you. So we're going to do something slightly different when you answer these. So what we'll be doing is the candidate who's asked the question will get 90 seconds for an initial answer. The other candidate will then get a 60-second response, and then the candidate who got the question posed originally will get a 30-second wrap-up. So it gives an opportunity, you know, if in the first round there were some times where the two of you wanted to respond to each other, now you can, okay? So a little bit more like racquetball this time. Okay, so what we're going to do is we're going to start off with Shanda. You will get the first question. And you'll have 90 seconds to start. What do you think of the county's Veterans Court? Have you ever sat through it? And if so, what were your observations? What can you do to expand these types of alternatives to usual course of the justice system, such that I'm sorry, let me try that again. What can you do to expand these types of alternatives to the usual course of the justice system, such that you're actively helping people who can benefit from them?
Yes, I have sat through Veterans Court several times, and I think it serves a very useful function. However, it is unfortunately a little too narrow at this point. Without going into great detail, the Veterans Court, who qualifies for Veterans Court is currently statutory. And so not as many people qualify for Veterans Court as perhaps possibly needed. So judges are limited to how many people can, or how many defendants can be in the Veterans Court system. I mean, there are going to be, as I've stated earlier, there is some additional money for these type of courts available. However, unfortunately, the statute limits the number of people. I think that the court here does a very good job, the judges do a very good job of getting as many people into Veterans Court as are possibly able to go in to Veterans Court. I think that it could always be expanded, and also I think that, I wouldn't say a better job could be done, but I do think communication between the courts and the available veteran services needs to be strengthened so that the court isn't simply making decisions for veterans on their treatment or their options without connecting them with those services.
Thank you. Sorry, that's a little quicker. A little quicker pace. Dawn, 60-second response.
First to start, the Veterans Courts and the judges are doing an outstanding job. I attend the Veterans Court and monitor it on a daily basis. They're doing great, and they have a very good success rate. The limitations on attending Veterans Court is you have to be probation eligible. Now, there's been some cases that brought to me that the charges that are charged are not probation eligible. But in the DA's office, we can adjust those charges, amend them, and make them eligible if necessary. And we do that on occasions, but we have to be careful not to abuse Veterans Court. 2 occasions I have stopped it because one was a child molester I would not allow into Veterans Court, and the other one involved a very serious violent crime. And even though the Veterans Court people wanted us to admit the defendant, I refused to do it when it was that violent.
Thank you. Shonda, 30 seconds.
Yeah, as I pointed out, the requirements for, excuse me, for Veterans Court are statutory and they include probation. So I really don't have much of a response to what Don said, other than it is important to make sure that people are in Veterans Courts for the right reasons, as well as you have to be able to connect the crime that's been committed with their service, with their military service.
Thank you. Next question goes to Dawn. Your strongest experience is in criminal law, but if you're elected, you would have to recuse yourself from the vast majority of criminal cases during the first 2 to 3 years of your term due to your prior involvement in those cases while serving as district attorney. And you can correct this if this is incorrect. This is the way the question was posed. As the court has only 4 full-time judges, do you think that would negatively impact the efficiency of the court and place you hearing cases where you don't have a lot of experience? Would the court system have to pay additional dollars to bring back retired judges to fill in? 90 seconds.
Wow, 90 seconds, that's a lot. Okay. First of all, it won't have much or little impact on the court as it stands now. There's several different divisions within the court. It is true that for a 2-year period, I cannot be assigned as the judge handling criminal cases. And that's for obvious reasons. Especially if my name is on the complaint, I can't be the judge trying the case. I would be assigned, no doubt, to family law, civil law, probate, so on and so forth. And that's something a judge has to do anyway. And so I fully expect that. Now, if a trial comes up, and I was not the district attorney when that crime was committed and sent over to the DA's office, I would be able to hear that trial. So there's not really going to be any substantial impact. And this is something we've seen. I'm not the first DA to run for office or to be elected. Judge Hedstrom, Judge Crone, Judge Martin, Judge Blum were all at one time in the district attorney's office who, they all turned out to be outstanding judges.
Thank you. Shanda.
So I think that Don is correct in pointing out that he would have to recuse himself for 2 years on criminal cases. I think the problem comes in is when you compare to Judge Hedstrom, Judge Crone, other judges, they were looking at 20 years on the bench. So those first couple of years were not as a significant percentage-wise of the time they were going to be on the bench. So I think that's where the concern comes in. However, Don is correct. There are other types of caseloads out there. They just aren't the criminal ones. They're more the civil ones.
Don, any response?
Yeah, just real briefly. Usually when a judge gets assigned to either like the civil division, family law, or misdemeanor crimes or felony crimes, they're usually in that for at least 2 years before they get reassigned to a different division. So there's really not going to be any effect on the justice system if I'm assigned to family law, which I do have like 20 years experience in family law, so we're not going in as the rookie, and well as civil law. I don't anticipate any problem at all.
Thank you. Next question goes to Shanda. We heard these mentioned a little earlier. What effect, in your opinion, will AB 1810 and SB 215 have on public safety? And to explain these laws to the audience, AB 1810, and again, you guys can correct me if I don't explain these correctly. AB 1810 includes a provision to allow defendants charged with any crime to get the charges put on hold and possibly dismissed if they can persuade a judge that the offense resulted from a mental disorder that a mental health expert rules as treatable. SB 215 would make defendants ineligible for community mental health treatment diversion programs if they are accused of murder, voluntary manslaughter, or rape. So again, just to repeat the question to Shanda, what effect do you think those will have on public safety?
So I think that there are several counties in California that have been using mental health courts, which is essentially what this is discussing. And you know, what mental health courts are designed to deal with are obviously not murder and rape and those type of things. It almost seems unnecessary to have added that extra bill, because that's not really what the concept is. The jails here and the court system are revolving doors of petty offenses that have something to do with a mental health condition, whether they're including some drug addictions and you know, what we would consider lifestyle crimes, the things that cause us a lot of problems. But the real problem isn't the fact that someone is stealing. The problem is they have a mental health condition that causes this. So I think that several counties, including Sacramento and Mendocino, have shown that these type of courts can be used to stop the unnecessary churn of these smaller misdemeanor cases that come in front of the court. In terms of things like, you know, murder or those type of things, there's always been an insanity defense that can be used in these areas, so I don't think that mental health courts are ever been designed for those type of offenses. So I think that the idea is to make sure that we're not punishing people for you know, stealing, you know, a radio when they should actually be dealing with their mental health problems.
Thanks. Dawn, 60 seconds.
First, the AB 1810 law, the mental health diversion, is not anything close or anything like a mental health court, and it's not anything like a insanity defense. It's completely different. At this point, we don't know whether they're going to be able to coexist with each other or not. It just that's yet remains to be seen. I explained briefly some of the problems we have with AB 1810, but more problems we have. It almost eliminates Marcy's Law, which is the Victims' Bill of Rights. Now, with Senate Bill 215, it gave back some of the rights, but not all of them. And with this AB 1810, anybody is eligible. It doesn't matter if they committed 20 murders in their past. They will be eligible. It's going to put the public at risk, putting these people back on the street. When they're going through the diversion classes and stuff, they are on the street, whether they're going to complete it or not. It's going to put the public at risk, but it's something we have to deal with. And we need a judge with the experience and the knowledge to say either yes or no. I'm sorry.
30-second wrap up. Shanda.
So I think that's correct. These type of decisions are put in the hands of the judges. They take the input of everyone from a probation department to mental health providers, and those decisions are made based on those facts. So I think that yes, there's always a possibility that something could, in the worst possible scenario, happen, and I'm not going to say that's not possible, but these type of decisions are left in the judge's hands because they have the individual facts on the ground.
Thank you. Dawn, the next question is for you. Okay, this is a long one. The California Code of Judicial Ethics requires, among other things, that a judge shall avoid impropriety and the appearance of impropriety in all of the judge's activities. In 2013, the Lake County Grand Jury wrote about the district attorney's alternative sentencing program, which he created, noting, quote, "The committee is concerned that the arbitrariness and lack of transparency of not only who receives the monies, but how much each defendant pays, puts the county and the DA's office at risk for an illusion of impropriety," end quote. The monies ended up totaling $250,000 or more, and you ignored the concern both of the grand jury and the board of supervisors and continued to be the sole determiner of who received funds. How can the voters trust you as a judge to avoid impropriety and the appearance of impropriety if you didn't bother to listen to the board of supervisors or a grand jury? 90 seconds.
First, I didn't ignore the grand jury's recommendation to do a committee to distribute the funds. I just, like I said before, I didn't agree with it and I didn't implement it. I left it up to my decision, along with input from the defense attorneys and the deputy DA who's handling the case. Now, with that being said, I kind of hate to say this, but I heard the radio show the other day, and my opponent alleged that I implemented this program to get votes and to get basically favors or get some consideration from the charities. And that's bull. Never once have I gotten anything in return from any of the money I've ever given to any charity. And I challenge anybody to bring somebody forward who say I did. There is no illusion of improprieties. I have given out about $250,000 to charities under this program. Some people criticize it, some people love it. I've given 95 distributions to 74 different charities. I have a list of the charities here. If anybody wants a copy of all the charities, I'm glad to give it to them. I've given to almost every single charity that has asked for money. There's only a couple I declined because of our policy. I do not give to law enforcement, I do not give to government, and I do not give to religious organizations for secular purposes.
Thank you. Shanda.
So I think my concern about this has been, it's sort of illustrated in the response that Don just gave. This money isn't his. He keeps saying that I have given money, I have given to charity, I have done this. This money is something that's done through the district attorney's office, and I have always believed and stated that there should have been a committee to have something a committee to decide who gets the money. Having one person make those decisions makes it ripe for problems. I once heard Don said that he gave children shoes. And it's not his money. And so I'm very concerned with that. I've heard numerous stories of people, and honestly one person told me that he gave money to their charities so they had to return the favor to vote for him. So that leads to the appearance of impropriety and people feeling like they have to reciprocate. And that is the concern I have with it. And to be fair, if it's continued in the same manner, I would have that same concern with another DA.
Thanks. Don, 30-second response.
Again, Rick, this thought that I have started this program and did this program to get votes. Well, first of all, I did this program 1 year into my first term. It was 3 years for the next election. I never asked for anything on this program. Not a thing. I will challenge anybody to say different. The people that voted me into office, trusting my decisions to make these type of decisions, and I still make it my decision. Okay.
Thank you. Next question is for Shanda. Our justice system in California has a very different approach to juveniles now than it did 5 years ago. Do you think the changes are good, and can you explain why or why not?
Are you speaking about juvenile dependency or delinquency?
Let's go both.
Let's go both, okay. So in terms of delinquency, the decision to move juveniles to a non-local facility has had impact on how the cases are heard. This has to do with a lot of different laws, and I think that, and how you treat juvenile defendants. I think it's made the best of a bad situation, but I'm not sure if I can weigh in as to whether it's good or bad. In terms of the dependency cases, I think that, well, and I have to say I'm a little biased, I'm looking to replace Judge Hedstrom on the bench, and I think he does a very thorough job in these cases and creates an incredible record that really adjudicates all the possible issues. So I don't know if that's the change we're discussing in terms of who took over that particular docket, but appeals are much easier to do than they used to be because he is so thorough in those aspects.
Thank you. Don?
Yes, as far as juvenile dependency, I don't think there's been much of any changes over the last several years. One of the biggest changes we've seen in juvenile laws, and I think the question refers to, is prior to the new law coming into effect, the district attorney's office can make decisions whether or not to charge a juvenile as an adult. Now the new law is changing that and twofold. You have to go to court to get in essence, permission to file the complaint, charging a juvenile as an adult. And also, it makes it impossible to charge, and I'm not sure of the age, but I think it's 12 years old, that you cannot charge any juvenile as an adult crime if you're under 12 years old.
I think that's correct, based on what I
Yeah.
read about that.
And it's not a bad thing, and nobody's really complaining about it.
Shanna, 30-second response?
I have to agree. I think that there's been some changes, and there are going to be some changes, but I think they, I haven't seen, in terms of delinquency, I haven't seen a huge change in the way it's affected the courts.
Do the two of you, can either one of you speak to, just quickly, how big of a percentage of the court's work deals with juvenile cases?
I don't know as an overall percentage. It's a somewhat large part of what I deal with, so it may seem large, a larger part of it, but I'd say maybe 20%.
Do you think?
Yeah.
I mean,
In
what do
the
you think?
criminal aspect, again, I have no stats, but I think 5 to 10% is juvenile work. And then you have juvenile dependency, which I don't think is more than 1 or 2%.
The juvenile dependency cases are very time intensive, so it's hard to tell in terms of numbers, but they are, you know, one case may take up, 3 to 4 hours of a court time, so.
Thank you. Dawn, next question is for you. In August of this year, this question writer writes, you changed your political affiliation to Republican after being a Democrat most of your life and shortly after not receiving the Democratic Party endorsement over your opponent this spring. You stated that you had changed your affiliation once before in 1995 when you were running for office because your campaign manager had told you that you would be more likely to win the race as a Democrat. Did you see a political advantage once again to run as a Republican in your race for Superior Court judge? Have you received an endorsement of any local Republican organizations?
First of all, I did not receive the endorsement because I'm not eligible to get the endorsement. You have to be Republican for a year before you can get an endorsement from the Republican Party. I'll tell you why I've changed my affiliation to Republican versus Democrat. My parents were Democrats when I first signed up when I was 18. And I stayed with it. I'm not much of a party politician. I never really believed in it very much. But over the last several years, the Democratic legislature and governor has done everything they can to erode the criminal justice system. And I am very much a staunch law and order type person. That's why I ran for district attorney. They have passed AB 109, Prop 4757. They've now 1810 and Senate Bill 215. I cannot be part of that organization who constantly coddles to the criminals and tries to undermine public safety by doing such a thing. And there's another reason too, which I'll get on after she responds. So you got your card up.
You still have 20 seconds.
20 seconds?
20 seconds?
Okay.
15 seconds now.
Okay. The other thing is, I cannot be part of an organization that will honor a man who will sit there and his only fame is to sit there and take a knee and disgrace the America and the national anthem.
Time.
I cannot. I should have waited.
Yeah.
10 more seconds.
Shanda.
So when we began this process in January, there were 2 candidates in the race, myself and Dawn, and then a third candidate, who I believe was a declined estate, got into the race. And because we were both Democrats, I went to the the endorsement committee, and I didn't see that they were endorsing anyone based on who would be the best Democrat, but who would be the best judge. So that's why I went after the endorsement. And I think that I think changing your party, after you don't get the endorsement speaks for itself.
Okay, now you get your final 30 seconds.
Like I said, I did not change to do the endorsement. I cannot get the endorsement. So that wasn't going to change for any reason such as that. I stated my reasons, and I'll stand by my reasons. Like I say, I am first a law and order type person, and that's the way I will follow.
Can I clarify something really quick in your question?
Sure.
You said that he changed parties from Republican to become a Democrat. He actually changed parties to become a Republican last time when he was running.
Okay.
The question was incorrect.
Okay, thank you. Okay, the next question is for Shanda.
Mhm.
Recognizing that the justice system sometimes re-victimizes people by putting them through testimony and trials, how can a judge minimize the trauma involved in that process, especially for women and child victims?
Yeah, this is a difficult issue. I think that courtroom settings are scary and that you have to make sure everyone understands what's going to happen with that, happen in the court, and make it as easy as possible for people. But court is what it is, and that you have to have everyone have their say in court. And I think that making it easier for victims is making the testimony as comfortable as possible without sacrificing the defendant, mostly the defendant's, right to a fair trial. And it's a balancing act.
Thank you. Dawn?
Hey, can you repeat the question, Liz? I'm
Sure. Recognizing that the justice system sometimes re-victimizes people by putting them through testimony and trials, how can a judge minimize the trauma involved in that process, especially for women and child victims?
Okay. As far as women victims, I wish there was a way, but the United States Constitution allows a defendant to confront his accuser, his witnesses. There's nothing we can do to change that. Nothing we should do to change that. The one thing we can do, which I see some judges do, not many, is in the family law circuit, is unfortunately oftentimes children are called to the stand to give testimony, sometimes against one parent or the other parent. A judge has the ability to say, no, we're not doing that, or we will do it with the court reporter and sometimes counsel, sometimes non-counsel, in chambers where it's a lot less stressful on the child. And when I do family law, I stress very much, keep the attorneys out of the chambers, just let the judge and the court reporter talk to the children, and they're going to get, not only get the truth a lot better, or whatever.
Thank you.
I'm going
Shanda?
to take that card away from you.
It's almost over.
I think there are options in family law that aren't there in a criminal setting because of the defendant's right to have a fair trial and confront their accusers. As I said, I think that there's just a balancing act that has to be undertaken, and the judge needs to set the proper tone in the courtroom so that everyone is treated with respect.
Thank you. Next question is for Dawn, and we still can take a few more questions. We're going to start to wrap up after the next few. Dawn, you mentioned this case earlier during the evening's questioning, but a Lakeport woman who was arrested earlier this year along with her husband for selling local teens into prostitution in the Bay Area reached a plea deal with your office, and on Tuesday, pleaded guilty to 1 count of human trafficking. You said that she was a victim herself who also has mental health issues, and so the plea won't have her serve prison time, but instead she'll have 3 years of probation, credit for 4 months served, and strict mental health treatment. And again, these issues have come up earlier tonight and we've addressed. You've said your office takes these cases extremely seriously, but today there's been some sharp criticism of the case resolution from community members who think that it will actually give human traffickers a green light because no prison time it will be served. So now that you're running as judge, not district attorney, so let me ask the question this way. How, as a judge, do you intend to approach human trafficking cases? Is there a way a judge can consistently handle these cases so as to send a message to traffickers that there are serious consequences for these crimes?
The judge can send a message by the sentencing of the defendant. And but the judge has to know all the facts of the case to do it. Sometimes you can be very hard, and the case you're talking about, the co-defendant faces a sentence of 111 years to life. He's not going to get the same deal as I gave the girl. That case was very unusual in that the girl had mental health issues. She was met by this man who later became her husband, and she was manipulated and mind controlled by this guy. There was no doubt. We've talked to many witnesses, many people that know her, and that's the way she was. And I cannot, in good conscience, send a handicapped girl to prison when she's been victimized herself. So what I did, I set up a program where she has strict mental health counseling, term of probation, and I believe in my heart that she's going to do well on probation and get back to be a normal, law-abiding person. That's my belief, and I'm sticking with it. I knew it was going to be a controversial decision, but I'm going to do what's right versus what's politically right.
Thank you. Shanda.
So I admit that what I have read about this case is strictly and mostly the article on Lake County News, but I was confused as to why someone who was, and admittedly in Dawn's words, a victim in this situation, pled to human trafficking. I don't quite understand how the two have, if someone is convicted of human trafficking, they should have the sentence that goes with a human trafficker. If someone was a victim in the case, then they should be a victim in the case and not convicted of human trafficking. So I'm simply confused on the facts of this question, of this particular case, and I hope as a judge, answering the question that you asked, as a judge would be fully informed on all these cases. This was a plea deal, so a judge in this matter would not have not been the one making this, not been the one issuing the sentence.
Thank you. Dawn, 30 seconds.
First of all, I knew the case. I know the case inside and out, the case I've been working on. This girl has no record, never been in trouble before. The sentencing is within the realm. My guess is if it went through probation, they would recommend probation for this person also. And just kind of as a side note, this person has the eligibility to go to mental health court if we had it. This person has the eligibility to go to a mental health diversion.
Time. Sorry, I went really fast. Okay. We're going to start winding down. We have a few more questions for each one of you. The next one just came in from the audience for Shanda. What effect will your current duties with the County Counsel's office have on your future judicial duties and assignments if you're elected?
So I actually did a sort of analysis of the cases that I'm currently handling, and I believe everybody's going to have some cases that they will be conflicted out on. We live in a small town, but there's probably very few cases that I would have to recuse myself on at this point. I came up with a number of about 9 to 10, and so I don't think it would have any real influence on what I could do in the court. I have a broad criminal and civil background, so it allows for a lot of things for me to jump in and do them, which I'm hoping to do.
Thank you. Dawn, response?
Just very briefly, there will always be conflicts, whether there's personal conflicts, social conflicts, whatever. Shanda will have very little conflicts as a result of her portion of county council. So it's just something that happens all the time with all the judges, and they work around it very well.
Thank you. Shanda, any?
Yeah, the courts have a system where they have a visiting judge deal with these type of cases. Every judge has, their friend's daughter who's getting a divorce or some type of these things. So the court does deal with it well, but as I said, I have very few that I've been able to identify.
next question is for Dawn. And again, you've talked a little bit about some of this previously tonight, but what do you think of the recent change to the law requiring mental health diversion? And as a judge, who would you select for these mental health diversion programs, and what do you envision these programs will look like as this new law is implemented?
That's one of the problems with this new law, is they don't give the courts or anybody guidelines to go through. It says to get into the mental health court, you don't have to be analyzed by a psychologist or a doctor. Any mental health expert, which could be almost anybody, can say, okay, you got this this mental health issue, you're eligible for mental health diversion. It's a very poorly written law, and hopefully it's going to be changed again and refined more and more. I'm confident that the courts are going to see through a lot of the problems that will come through with this, like who's eligible, who's not eligible. But every now and then, someone's going to slip through the cracks, and the public's going to get hurt because people who are on the street should not be on the street. They should either be in an institution, in jail, or even on probation.
Shanda.
So from a practical standpoint, both with this law that was instituted, as well as AB 1437, as well as the bail law that just went through, the Judicial Council will be or has already, in one case, convened working groups to come up with standards on how these are applied. So obviously, in any day-to-day case, there's going to be, the individual judge will have to make the decision, but there will be, these laws will be considered by the Judicial Council and guidelines will be issued. So, so I think it's kind of a stay tuned on how those things are going to be handled globally across the state.
Dawn, any final response?
One last thing is, it'd be great to get people with mental health issues the treatment that they need. Unfortunately, the legislature has given the county no money to implement this. It's all coming out of the general fund, and everybody knows our finances now. So how much quality they're going to get is very much in question. I don't think it's too optimistic at all.
Thank you. Okay, before we wrap up for the evening, Shanda, do you have a question for Dawn?
Do I have a question for Don?
Yes, you get to ask him a question.
I would be curious as to why you want to be a judge.
A lot of reasons. One, when I was elected DA, I had a mission. I've completed that mission. I've done everything I set out to do. Now I want to go on to a next step, another higher degree in the judicial system. I want the challenge, and I expect it to be a challenge. It's just a natural progression in my life. This is my last, you might say my last hurrah, and give everything I can. And I think I have the temperament for it. Well, I know I have the temperament, not just think, I know I have the temperament for it and the ability to do it. And I bring in the experience of my days from law enforcement to private practice to the DA's office. So I think I can do I know I can do the job well and become a good judge of this.
Do you have any follow-up for him on his answer? Okay, Dawn, you get to ask her one now too.
In a radio interview you did the other day, the moderator asked you about the number of trials that you have done compared to myself, saying I've done quite a bit more, which is like, a bunch more. And your response was, it's not the quantity of the trials, but it's the quality of the trials. So my question to you, do you feel you've done more serious trials than I have? Is that what you were trying to say? Or how would you compare the trials you have done versus the trials that I have done?
So I was talking about the fact that I've had a very broad experience in terms of the type of trials that I've done. I've done big corporate litigation, which is very preparation intensive, and I've practiced in various different courts, and I think those cases have been very instructive to me. But what I was saying was that it's not a number of cases. Anyone can go in and try a case. You have to disagree, or you have to file a case and end up not agreeing or not coming to a conclusion. It's not that somehow having more numbers is meaning that you're a better attorney or you have more experience.
You have a follow-up question on that?
It's kind of a question or statement. You said in that same interview you've done 3 misdemeanor jury trials, which are minor crimes, and 3 small personal injury car accident type cases. I believe that's what your statement. Do you consider that adequate to hold, to be a judge on cases involving murder, robbery, sexual assault, child molest cases? And maybe lastly, when you said anyone can do a trial, but the question is, my question to you, do you think anyone can do a trial effectively?
So that's actually not what I said on the radio. Just to be clear, what I said was that I had done a total of 9 trials in various different positions. When you do big corporate litigation, there is not, they have more than one attorney on a case. So the question was posed to me about how many have you done, first chair or only attorney on the case, and so I divided them into different cases. And actually the answer to your question is, I do not think just doing it that anyone can do a case effectively. And so I think that that's the point that I was making, that just because people have done, or someone has done an immense amount of trials or a number of different things, that they are somehow have more experience. Do I believe I have enough experience to do this? Absolutely. I have been in front of the appellate courts. I've been in front of various different courts in this county and other counties, and I have no doubt that I have the education and experience to do this.
Thank you. Okay, we have asked and answered every question tonight, so thank you both. We're now going to work into the closing statements. So if you still have a little something you'd like to say tonight, you get to wrap up. You can go back to any of the questions, you can bring up new material. It's entirely up to you. So we're going to go in reverse order from the opening. So that means that Shanda will start with her 2 minutes.
So we've heard a lot of different issues here tonight, but I want to tell you, in a sense, who I am and why I want to be a judge. I have always wanted to be a judge. I think that my temperament, my education, my sort of way of viewing the world in a neutral fashion are absolutely appropriate for the judiciary. I have done everything I can do to have a broad education, a broad way, not a broad way, I'm sorry, a broad diversity to the type of law that I have practiced, and I guarantee anyone who comes into my court an experience that they know that they have been treated well. And this doesn't mean that they're going to get what they want. It means that I think that it is the highest responsibility of a judge to set the tone in the court and to make sure that everyone is respected. The judge is responsible for everything, and I think I'm well suited and prepared to be responsible in my court and to set the tone going forward. So I look forward to working very hard for Lake County going forward in the future.
Thank you. Dawn?
My whole campaign here has been based a lot upon experience. But it's not just the experience you have, it's what the experience makes you, what type of person your experience is. And that's something I think I have much more so over my opponent, is the life experience as well as the legal experience. the life experience, I can't tell you, I'm sure Brian Martin can tell you, that if you're a deputy sheriff, you get experience in life every single night. You learn from that, and it formulates you as a person. The legal experience, I know Ms. Harry says she has a broad, vast experience, but when you sit back and look at what she has done compared to what I have done, it's a huge difference in the legal form. And when it comes to the courtroom, you have to have the experience. And why experience is so important in courtroom is you have to rule instantly on rules of evidence, on procedures, on such as that. And if you don't have that experience in the courtroom, you're going to make mistakes. It's just natural. Now I know judges now who've been on the bench for 20, 30 years make the mistakes. At least I think they do. They don't think they do, but I do. But you have to have some foundation to know the difference. And that's something I bring to the table, and is not only the experience of the courtroom and the law, but the experience in life. And maybe the life experience is the most important experience any judge will have, to know how to deal with people, know how to understand people, and really understand, show compassion when necessary, and show firmness when necessary.
Thank you. Well, that is our debate. Thank you both very much for taking part tonight. I wish you both good luck this fall season. Thank you to the community who took part and submitted questions. Please remember to vote this November, and if you haven't registered, October 22nd is the deadline, according to the Registrar of Voters Office. Thank you to the Lake County Economic Development Corp. Also for their help. And this formal debate will be on Lake County News. Thank you very much. Have a great night.
Thank you, Elizabeth.
Thank you.